So without further ado, let me introduce David Heckler. He's the co-chair of our cybersecurity working group. David, I'll just pass it to you, pass the mic to you.
Thanks, Chris. Before we get started, I'm just going to mention that in addition to this video being available on the in-house website, we're going to post articles that are of interest as well. We actually had in security an interview with the legislative lawyer for the Electronic Frontier Foundation in California, who talked about the General Data Protection Regulation out of the European Union, which went into effect in May. He talked about California's Consumer Privacy Act, which was passed in June, but doesn't go into effect until 2020. And he didn't talk about the Colorado legislation, which I don't think he knew about, nor did I. And that's what we're going to be talking about today. The Colorado Consumer Data Privacy Act was actually passed in May and went into effect in September. So it's actually, as far as I know, if anyone can correct us, let us know. It's the only state law of this nature, widely applicable law for Colorado residents and employees, anyone who does business in Colorado. And Kirke Snyder is going to talk about that in a minute. But privacy and legislation are, clearly front and center. And there have been congressional hearings on this recently that you're all aware of. And there's a lot of talk about the possibility of national legislation, federal legislation, that could even preempt all the state laws and beyond. And that's why we thought this is a particularly good time to invite Kirke Snyder, who happens to be an in-house member, to talk about this subject while all the lobbying is going on before things really heat up. Kirke is a certified information governance professional with over 25 years experience helping clients solve litigation, e-discovery, records management, and information security related issues. He earned a JD degree and a master's degree in legal administration. He's also a practice leader for Chorus Consulting, LLC, and has been an adjunct professor of law and ethics at Regis University School for Professional Studies in Denver, Colorado for more than 20 years now. And that's why he could tell us that there's something going on in Colorado that we should know about. So Kirke is going to talk for, as Chris said, maybe 10 minutes or so. And then the rest of the whole session is open to your comments and questions. Okay, Kirke.
Thanks, David, and good morning, everyone, wherever you are. I wanted to start by asking kind of a question I might ask to my MBA students. What do a large defense contractor, a national life insurance company, a national vehicle leasing company, and a hospital conglomerate all have in common? Well, of course, I had the answer. First, they're all prior clients of mine, and second, and most importantly, none of them are in compliance with this new Colorado law. They all have a records and information management policy and program in place. They all have a data privacy program in place, but none of them are in compliance with this new Colorado law. The reasons that they're not in compliance, and there's several, is that like I say, there's several. First, none of them have agreements in place with their third parties or agents, vendors, to to require them to maintain reasonable privacy standards for their personally identifiable information. In the case of the hospital conglomerate, they are receiving information from agents or doctors that are sending over records from patient records. With regards to the vehicle leasing company, they are receiving driver's license and credit card information from travel agents and other kind of third parties. And they are actually the processors of that information. If it's the law requires that not only you maintain reasonable security measures, but you have a contractual agreement with these vendors and third parties that could be a cloud provider with whom you're sharing personally identifiable information, that they will also maintain those standards. So, here's a great opportunity for attorneys to get back to their clients and help them really think through where their information is going, and reach out to those folks and either redraft or renegotiate those agreements. There's another reason they're not in compliance, and that is that the law requires that the companies delete or destroy unnecessary or obsolete data documents with PII when they're obsolete or unnecessary. None of the clients that I mentioned have updated their retention policy and schedule to indicate that the destruction should be immediate upon being unnecessary. Which brings up the question: what is unnecessary? What if I have prospect information that I have collected because of visits to a website or what have you, and if I'm still trying to market to those people, does that still mean that it's necessary? These are all great questions to talk through. The Colorado law came into effect just a month ago. The California law hasn't been in effect yet, as David said. So there's not a lot of guidance in terms of regulatory guidance or case law or whatever. There are a lot of opinions, floating around of legal scholars and so forth. But the keys to the Colorado law it requires a very quick notification of anybody, a Colorado resident affected by a data breach, 30-day notice. And I would say that the clients that I just mentioned don't have the ability to actually identify, if they had a data breach, which of those individuals whose information was compromised might be affected and therefore need to have a notice. Colorado law also says if more than 500 Colorado residents are affected in the breach, the Attorney General has to be notified in that same time period. So it's definitely, the Colorado law is not as focused on large internet providers like the California law. It doesn't have the provisions of opting in and opting out and transferring data from one jurisdiction to another like GDPR does. But it does have some requirements that these other regulations don't have that will trip people up. The question that I ask my clients is, what is your philosophy of information governance now? Is it going to be to just identify any employees or clients or agents or third parties that reside in California or Colorado, and come up with some sort of a special program that if for these people we do these things, but for everybody else it's business as usual? Or do you restructure your entire information governance, data privacy, et cetera, to meet the most stringent requirements throughout the United States? And of course, other states are going to jump on the bandwagon. Colorado has been pretty notorious with their cannabis laws of kind of leading the legislative process of other states, looking at what Colorado has done and jumping on the bandwagon. And I don't doubt for a minute that other states are looking at what Colorado has done and what California has done, and they're going to come up with their own brand of this data privacy, data protection. And of course, ultimately, this is going to force the hand of the federal government to come up with some kind of a unified data privacy legislation, for all of the states. But it'll probably take a while, and clearly the lobbyists that work for the big internet marketing companies are lobbying like crazy to make sure that these laws are not too oppressive to their clients and what they're trying to do. So the Colorado laws here, it's in existence. From a legal standpoint, I think it means that there's a lot of work that can be done. There's a technical part that they probably need to put in place some sort of a technology utility that has built-in algorithms that will basically spider out to all of the storage endpoints, whether they be servers or desktops, laptops, or even cloud storage, to identify does this storage device have PII based on some algorithm that spots credit card information or driver's licenses or student IDs or what have you, and then reports that information back to a information security person or a law department or consultant or what have you. What do we have? Where's it located? And then provides a mean to track it, so that if you have a data breach, you can very quickly identify who was affected, what records, what individuals, and then provide them notice and then document that this was all done. So there is a technology component. There's no question, but there's also a legal component. There's rewriting policies and as I mentioned earlier, helping them redraft and perhaps renegotiate vendor contracts, I think it would be a real natural fit for you people on the call, perhaps. So let me stop here and open it up, turn it back to David and Chris, and see if there's any questions, comments, or where do you want to take this discussion about data privacy regulations in general, or specifically the new Colorado law?
I'm going to jump back in for just a second. David Heckler here. Just so you know, I interviewed Kirk, and that interview will also be posted on the In the House website when it's ready. And also, if you look down in your chat window, you'll see a link to the article we have now on the on the cyber insecurity website. That is the article I mentioned earlier that talks about GDPR and the California legislation and speculates about the possibilities of federal legislation. Okay. Anyway, so now it's all yours. Take it away. Anyone who has a question or comment, and Chris and I have our own questions if there's a pause.
And again, I've muted all, so unmute in the lower left-hand corner. You can unmute yourself if you're having issues with being heard. So just
Hi, can you hear me?
yes,
We
is
hear
that
you.
Yes.
Sam?
Perfect. So I had two questions actually. One's more of a general, like when people say cybersecurity, I think in my head at least I break it up into two pockets, right? There's the sort of a terrorist sort of international risk thing, and then there's like cybersecurity is like data protection, right? So my question is sort of a two-pronged question. One, I think that the thing that struck me the most about the Colorado law is that there's actually sanctions that can be that the customers can bring against the companies, like monetary sanctions if they're not compliant. When I was reading it a few days ago, do customers, do you think that actually will happen, that somebody will bring a $500,000 suit if you're a giant insurance company doesn't give them their information in 30 days? That's my first question. I mean, how effective are the actual sanctions in the law is in making these large companies do what they're supposed to be doing?
Sure, that's a great great question. And depending upon the state, depending upon the legislation, they've written it in different ways. Some of the states have written, and California's written that there's specific monetary sanctions. Colorado didn't. Colorado says this is really up to the attorney general to bring either civil or criminal penalties, and they can do. And the attorney general can do whatever they want to do, basically. And you know, does that preclude negligence suits brought by shareholders or affected parties for management not taking reasonable steps to safeguard their information? I don't know. What do you guys think?
And then there's no assumption of the risk there either, I guess, right? Because that's thrown out the window now because of this law. I mean, when we all put our stuff in the cloud, we didn't know better, right? I mean, that's another issue I have, right? I mean, was I supposed to know that things could get hacked when I was 22 and just started putting things up in whatever, I don't know what it is, the cloud?
Well, if you were 23, I think it would be different. But
or whatever it was.
I think you're off the hook.
Luckily, that didn't exist when I was 22. So,
that's the other question I have. I mean, a lot of this stuff might be statutorily prohibited now, but now I'm sort of concerned that people will say, these larger companies will say, and have said a little bit, well, you know, Facebook was, Mark Zuckerberg was 19 when he made it. Kind of a little bit of his theory, you know, we just trying to make a social platform. We didn't really know what we were doing, sort of thing.
Well, one other thing about the Colorado law that I neglected to mention, it applies to every company, regardless of size, one employee to multinational and government agencies. So in terms of an opportunity to get back to a client to talk about this and talk about, you know, contracts and what are they doing and so forth, it's kind of a consultant and lawyer's dream come true.
Right. Yeah, and I guess my other question is going back to the bigger data issue in general. I mean, I worked on Wall Street when the banks fell apart, after they fell apart. And I was reading emails from 1999 and 2001, and I was like, everybody, and I was shocked then, and kind of, I was like, people knew this was going to happen years before it happened. And then sort of like when now this CSR and impact investing things are behind them, and people don't want to change just because they don't want to change. And it's sort of the same thing over and over again in the States, I think. And the EU sort of ahead of the game again with like data protection and cyber. So back to what you were saying about a policy, like an information governance policy. I mean, it seems to me that it would make sense once for like people to just make the changes before there's a problem, because it would be cheaper and more effective to do it before everybody just gets sued and the world falls apart.
Well, change is it does not come easily, and I must be candid that I've had more than one client where we have sat down, I've done interviews with every department to determine oh gee, we have documents and data with PII in electronic format and hard copy format, and they're located all over the organization, and it's offsite, it's in Iron Mountain, and I've laid out a plan of how to remediate that and what to do. And they've come back and said, nah, thank you very much, but nah, we're not going to do it.
Yeah.
So what do you do except, you are a counselor and you counsel, and just like with a marriage counselor, that sometimes they follow your advice.
And how do you mitigate the risk though? I mean, especially if you're an in-house counsel, are you responsible then when
that's the tough part, because as you know, in-house, you have, legal and ethical duties, and if they refuse to take your advice and you feel like you may be on the hook for that, I think that you have to back away and actually take your concerns to the board, and then leave.
Okay.
Anybody else want to comment on that? Chris, David?
I often see that the head of IT wants to make the general counsel responsible for everything. Yeah. And the general counsel, me, I want to make the head of IT responsible for everything.
Yeah.
It's often a tension.
If the company refuses to take your advice of here's what the law is, here's what we need to do, and regardless what the law is, do you feel like the only thing you can do is bring it to the highest level? And if they still refuse to back out of the relationship,
or at least get it in writing.
The only comment I have is I think this issue is exacerbated by the traditional, I guess there's a little dysfunction traditionally between lawyers and tech folks who not speaking enough to each other. And I think that it does exacerbate this issue of things falling between the cracks, or maybe passing the buck to the other team member in your executive suite. But I think the answer for me is both the GC and the CTO need to own this issue. And increasingly, there's a chief privacy officer or a CISO, somebody like that. And I think both people need to own it, but then you need to break it down into tasks and figure out who owns what aspect. So the ownership top level question just begs the question of, well, we need to break this down. And another role, I think, are outside advisors, because unless you're a giant company, it's unlikely you can have a full-time person doing nothing but cyber privacy and cybersecurity legal. Great if you can do that, if you're a giant bank or something. But if you're a company with, 50, even, definitely 20 or fewer in-house counsel, you may not be able to afford to have a full-time person doing nothing but this stuff. So I think services like Kirk's company and other similar services and outside consultants who have a lot of cybersecurity legal experience can be a tremendous asset to companies.
I'll just point out that last month, our subject was the divide between the chief information security officers and general counsel and in-house lawyers. We had an interview. We're going to post an interview with Sally Osman, who was the CISO who was talking, and we're going to post that recording of that session on the in-house website. But this is a continuing issue that will come up again and again, just as the privacy legislation is going to be in the news for the next year. So we're hitting some big topics here.
And I want to ask you, did you see the current administration's, anyone I guess can answer this, what they released recently of the cybersecurity risk plan? I think they released 2 of them. It was fairly generalized, but a a little bit, like 10 pages. I can send it to everybody if they want. But Cornell sent it to me a few weeks ago. It's proposed cybersecurity regulations in 2018 and 19 from the government. It was just, I mean, I just was reading it a few days ago. Regardless, it's there. His action plan trumps. I guess it might have been in response to Colorado's implementing the law. But the takeaways are really not much, shockingly. But it basically says that they're going to do the best they can to do the best they can is really what I got from it. But they didn't really mention anything about domestic. They didn't really address the issue of Colorado, which I think was why he put this out, which is like they didn't really address big businesses at all and kind of cramping down on that at all. But they really mostly focused on terrorism as an issue. And even then they really didn't get much into how they were going to address that by cramping down on information security. They were like, well, so I was sort of like, well, if this is your answer, which isn't really an answer, and you didn't even address that, and you didn't focus at all on cramping down on at all regulating big business in any way, which I think is what it was trying to even address. Where do you see the federal government even going? Or are they just going to sort of just kind of turn things out like this to sort of just keep saying, so people can say, look, he's trying to work on something?
That's a good question. I can tell you what Colorado says is that businesses need to take reasonable measures to protect personal information, and they specifically don't define what the reasonable measures are because they want to say what they're going to require a small company to do is quite different than a big company, and depending upon the sensitivity of the data, it would require different measures. So I have put together a checklist, a proactive checklist of what I recommend to my clients, that the steps that they take. I've sent over a PDF to Chris. I think Chris is going to provide that to everyone on this call. Is that right, Chris?
Yes. Yeah, I'll be doing that after the call later, hopefully later today. If not today, then tomorrow, and you can all take a look at that. I can also do a quick screen share of it now if that's helpful. I don't know, but I didn't want to dictate.
No, it's not necessarily something I want to go through, but I want everyone to know that when it comes to reasonable measures, you almost have to go back to law school and think about the negligence standard of what would someone in this position do that people would find that was reasonable. And if you're a multinational company, obviously it's different than a ma and pa art framing store, but the art framing store that's collecting customer information and credit card information and contact information, they're not off the hook. I mean, there's still things that need to be done. So once again, as members of in the House, I think it's a tremendous opportunity, just like when I was with Anderson, then Deloitte and Touche, when Sarbanes-Oxley came into effect. We looked at each other and thought, wow, this is great. We get to go back to all of our clients and create a huge project to become Sarbanes-Oxley compliant. And it generated a ton of billable time to prove that our clients are doing the right thing to track transactions and so forth to be compliant with Sarbanes-Oxley. I see this as a kind of a similar thing, and attorneys can either sit back and let the technology people, take the leadership on this, or they can take the lead. And I think it's a legal risk issue, and I think it's appropriate for us to read up on this and to start the conversation.
Yeah, and I just want to jump in. I completely agree. The only thing I would add to what Kirk said is I think this is a classic project for the skill set that is almost unique to in-house counsel, which is being expert legal risk managers. So I think that a big chunk of this work should be done by experienced in-house lawyers, and I don't think it should just be a boondoggle for big law firms. I think that would be a strategic mistake for companies. I'm a bit biased as the founder of this community for in-house lawyers, but I really think this is a classic opportunity for in-house lawyers. If you're at a big company, at a big legal department, polish your credentials, present yourself as someone who can help solve this issue. If you are a solo GC, get some help from someone who knows what they're doing, who has a lot of in-house experience. But this is a real career opportunity for, I think, experienced in-house lawyers. I think that you're better situated than your peers at law firms to tackle this issue. And, doing a project-based approach is really appropriate because, as Kirk sort of suggested, it's a balance, right? How much you do really, in the end of the day, it's going to come down to reasonableness. It's not going to look under every rock and research every issue and do a memo about it. That's not the right approach to this. Maybe if you're a Fortune 500 company, but maybe not even then.
The big law firms, certainly the AmLaw list, all have one or two attorneys that are listed on their website as either practice leaders or knowledgeable about these topics, but it's a second or a third major for them, and their primary major is typically litigation. So you could read into that what you want, but law firms, they're not the answer to this, and I really think it's for it's there waiting for us to pick up the torch and help. We talked about the role that legal plays and IT plays, but really in these projects that I've done a bunch of them in my career. You've got to get the business units involved and the business unit leaders to buy into the kind of change and the things that you are suggesting. And so having an in-house approach of putting together a steering committee of the people that we just talked about and representatives of the key stakeholders, and educate them on what needs to be done and why, and to tell them. I had a client just a few weeks ago that said, we save everything forever. We don't delete anything. And when I said, well, you can't do that. I mean, you can't. Well, why not? That seems to be the safest way. Well, there are rules and laws and regulations that require that you do delete some things. And they looked at me like, well, that's weird. And it was an education session of and a mapping of their data and exposing to them. You've got all these hard copy documents on Iron Mountain that somebody's got to pull those boxes and figure out what's in them and either redact or destroy the stuff that needs to be destroyed. And these are not projects that are a week or a month. They are projects that have legs that could go on for well more than a year. I've had projects that have gone on for 2.5 years.
I want to give a 10-minute warning because we do have a hard stop right at 10:50. So we got about 10 minutes. So last questions for Kirk, please give them now, and don't forget to tune in monthly for this video conference.
I had a question. This Colorado law and also the California law, it raises this issue of there's now going to be like quite a few different jurisdictions and sets of laws that apply to data protection, data storage, personal identifiable information. And then we just went through the whole GDPR thing for Europe, and it seemed like that was going to be the hardest standard to meet. And there was this sense that, like, well, if we comply with GDPR, then we'll be complying with everything else. And I think to a large extent that may be true, but it's just interesting that there are these other laws coming in and then just even different nomenclature, like how they, in the US it's called personally identifiable information. In Europe it's called personal data.
Yep.
And then when it comes down to us crafting, a a data compliance policy, a terms of use, a privacy policy, it's sort of a bit of an open question. Like, do we do it according to like these looser U.S. standards, or do we just take a great policy from GDP that applies to GDPR and its whole regulatory scheme, and then adapt that to America and an American business website? I'm talking mostly for smaller companies. So I'm just wondering if you had any thoughts about that. I know it's
great question, David. The unfortunately, and as you say, GDPR is certainly the biggest and the broadest and so forth. But the Colorado law has some things in it that GDPR doesn't even address. Consequently, GDPR addresses a lot of things. A host of things that Colorado, doesn't. I would say that the California law and GDPR are much closer, but they're different. But it goes back to my question of philosophy. Do you try to okay, for these people we're going to do this, and for these people we're going to do that, or do you really try to think about what are the most stringent standards? If we don't deal with data of European residents, let's not worry about GDPR. I have a utility that we install on clients' electronically stored information that will identify PII, and then do a search to determine as best they can where do these people reside, based on a state code or an area code in their phone number. Sometimes it's not possible. But to answer the question, do we have anyone that even resides in Colorado or California? I mean, does this even apply to us? It's kind of what people talk about first. But I would say that if you're doing business in Vermont and you have vacationers that come and you're collecting information, customer information for people who are even visiting from Colorado or California, I guess we do, so it's tricky.
Probably have room for like one more question from anybody else who'd like to ask Kirk.
I guess, where do you see this going in the next 2 months in terms of, do you think the next big thing is going to be in the security side or the content side, like regulatory and content side, or the actual information side? I just this general question.
Samantha, in the next 2 months,
I
think the best thing that we can do is educate.
Okay.
And reach out to clients and former clients and prospective clients and educate them. Do you realize that this is now the law, and this how it might impact you? And look at my checklist and read of what are the things that you might see yourself doing that could help this client. We can't do all of it, but we could certainly do this. And don't be afraid to team up with somebody like us, that we do the technology part, but we're not going to negotiate contracts. That's not our specialty, but we sure as heck can identify the PII and help remediate it and put in a system that will either encrypt data at rest or monitor it. So if there's a breach, they know exactly what to do. But I think partnering and educating is what I would do in the next 2 months.
Thank you.
Well, I wanted to thank Kirk so much and thank David, our co-chair of the cybersecurity practice group here at In the House. I was inspired by the large group who showed up today, so I just posted a one-day sale. So anyone who's on the fence and hasn't joined In the House officially, I'm offering 40% off just for one day on a lifetime membership. So I think it's under $150, and you join and you're done. And, you know, we do have costs here at In the House. So when people join, that really benefits the community. And all our events are free. So if you join at any level, you can participate in our live events in New York City. You can join any of our online events, and just go to inthehouse.org, click on join us, and I hope that all of you will consider that. It's a real good deal, I think, for the kind of expertise that Kirk and others offer. And by the way, I always like to mention at the end of a call that we're actively seeking other thought leaders, because we don't, you know, in-house is more about, you know, more than just peer networking between in-house counsel, although I think that's very valuable in itself. We also want to pull thought leaders out of the community so that you can share your knowledge with others. We do have several people on this call who have done that, and I think it's an outstanding way to present yourself as an expert in whatever your area is in front of other in-house counsel thought leaders. And I think that in order to succeed as an in-house lawyer, it's not really an easy path these days. And I think that you need to be thinking about, where's your career going? If your company gets involved in a merger, or for some other reason you're looking for a new opportunity, who are you going to call? And if you do not have a recognized, if you don't have a peer leadership position within the in-house community, I think that makes it tougher. So I really encourage you all to get more involved in the House. We're going to be creating more and more working groups. So please step forward. I'm easy to find. Just reach out to me at chris@inthehouse.org. I talk to in-house counsel, literally 2 or 3 in-house counsel a day, and get ideas and you know, feedback. And you know, we want to build this community into something that will serve all in-house counsel and help you all sort of succeed in your careers. So on that note, thanks again, Kirk. Thanks again, David. We do these on, what is it, David? The second Thursday of each month.
10
and
o'clock.
we Thursday at 10 o'clock on the second Thursday of each month.
I
So
didn't mention
yes.
There's a PLI that's live webcast on cybersecurity. I think it's in 2 weeks.
Okay, if you want to give me the link, I'll include it in the post. So Sam, just email me that link,
And you can,
and I will include it in the email that goes out.
and Sam, you can also send a link to that document that you mentioned earlier.
Oh, I just did that to him actually already.
Great. Okay.
But yeah, I will.
Excellent.
Perfect. I wish I could stay and we could extend this, but we will. Well, we'll pick it back up next month, and we'll have another great speaker, another great topic. So thanks again, everybody.
Thank you.
And enjoy the rest of your day and the rest of your week.
Thank you.
Bye.